Hello, everyone, and today is Monday, March the 16th, 2026, and you have joined Ask a Care Navigator, Mondays with Maureen. Hello, everyone. My name is Maureen Williams, and I'm the Director of Care Navigation here at Four Seasons, the Care You Trust. And we try to create this space on most Mondays to talk about issues associated with living well and aging well and how Four Seasons may be of service. If you have any questions at any time about Four Seasons, please call us 866-466-9734 or go to our website, which is fourseasonscare.org. Please spell out the number 4, FOURSEASONSCARE.org, or you can drop a question or comment into the comment box from whichever platform you're viewing, and we're glad that you're here. We'll have a special guest, so stay tuned. And he is from the Van Winkle Law Firm. And I am so grateful to the Van Winkle Law Firm for serving as the title sponsors for this program, Ask a Care Navigator. The Van Winkle Law Firm is one of the most established and well-respected law firms in North Carolina, providing exceptional legal representation for individuals, families, and businesses in legal matters, including estate planning matters I particularly interface with them, commercial, business, and personal legal matters. Should you want more information about the Van Winkle Law Firm, please go to the website, and you'll see it in the comment box after this program. It is www.vwlawfirm.com, and you can look for information and request a consultation, and they'll take very good care of you. Well, my special guest is with the Van Winkle Law Firm, and this is Lucas Moomaw. Tell us about yourself.
Thank you, Maureen, and I'm happy to be on your program today.
Yes.
I have been practicing with Van Winkle for about 5 years, so I joined in summer of 2020. Interesting time.
It was interesting.
Join the law firm. Prior to joining the firm, I went to Wake Forest University for law school, and I was in the elder law clinic at Wake Forest. So that is one thing that sort of sparked my interest in elder law. I've been practicing in traditional estate and trust planning and administration for most of the time that I've been here with the firm. And I've started integrating elder law, Medicaid planning into my work here at the firm.
Love that. And a lot of the topics that Lucas and his colleagues are going to be presenting are common questions that I run into, and they're graciously talking about this. And I do run into this topic of Medicaid a lot with the clients I serve. So, Lucas, tell us about what is Medicaid and how are you eligible for Medicaid? Why do we need to know?
Right. And before I get into any sort of Medicaid specific or sort of elder law tips, I have to say that this is just general information. We're sort of discussing the contours and the general rules around Medicaid today. None of this should be construed to be legal advice. If somebody is interested in getting further information or getting sort of a customized plan of their own, I would recommend certainly working with an experienced elder law attorney.
Absolutely.
So with that, I would say Medicaid is a federally funded program that's administered at the state level. Generally, the goal of Medicaid is to assist individuals who cannot afford health care or long-term care otherwise to pay for that care.
Right.
And as a program, it's broken down broadly into two categories. So there's the categorically needy population, and funds for that population are designed to help people with limited income and resources who are in certain categories. So thinking pregnant women or children, individuals with disabilities. And then there's the medically needy category or group, and that's what we'll be spending most of our time talking about today.
And that's the group I interface with as well.
Right, and that would be a group usually older adults who are needing long-term care and needing that in a facility of some sort. Perhaps it's no longer safe or reasonable to live at income. And then the question is, how do people pay for that care? Because, of course, long-term care is quite expensive for the majority of folks. And we'll discuss in a little bit, but Medicaid is only one of the avenues in which somebody can pay for long-term care. But in order to become an individual that's part of this medically needy class, there has to be a demonstration of medical need. So the requirement of being in a place that is safer than the home, perhaps, for care. And then there also are financial criteria. And so that, otherwise stated, is having very few assets in order to qualify for Medicaid, so that the government is picking up the tab for long-term care. There is a formal application to receive Medicaid. It's not an automatic process, so it's different from something like Social Security in that regard. And it's Medicaid itself is administered by the North Carolina Department of Health and Human Services, but the application process is overseen by the county DSS, where somebody is a resident. And so that eligibility process is a fact-intensive inquiry that DSS is making into someone's assets and their financial life. And so that involves an audit of all financial records, not just at the time that somebody needs Medicaid, but actually some of the listeners might have heard of the look-back period, which is 60 months or 5 years from something we'll discuss in a moment called the snapshot date, which is sort of
the line in the sand.
The line in the sand. Yeah, that's when somebody needs Medicaid. And so one aspect where an attorney might be helpful in the Medicaid application process is in helping get information organized, reviewing things to help spot potential red flags before folks submit the application and seek Medicaid. The other point in time in which an attorney might be helpful is following the death of somebody who has received Medicaid. And I just bring that up because Medicaid eligibility is planning at two distinct phases, but planning at the same time.
Right.
So for that, I like to think of Medicaid as a loan program more so than an entitlement program. And we'll talk about some things that people can consider doing in order to preserve assets. But if somebody's coming to speak with an attorney about Medicaid eligibility, that's often the overarching goal, is try to preserve assets for future generations and keep family legacies intact in that way.
If I can jump in, thank you for bringing that up, because many of you all who watch, who've interfaced with me over the years, this is important, is preserving the assets that do exist. And that's where I think the services of an estate or elder law attorney, they're invaluable. It's worth it. So it's just the right thing to do for everybody.
And so getting into the sort of the nuts and bolts of what DSS will be looking for when conducting an eligibility determination, the first thing to consider is someone's income. And technically there is no income cap for Medicaid. The catch here is that any income that someone earns has to go towards care. So in that way, all income gets caught in the net, so to speak. The person receiving care in the nursing home is entitled to a $30 monthly personal allowance. Of course, that doesn't go very far, but the idea is that Medicaid would be paying for all room and board and care that is necessary in the nursing home facility, most commonly.
Right.
Before I shift to talking about what assets somebody is allowed to have or not have in order to become eligible for Medicaid, I should highlight that when looking at assets, DSS is looking at the the total of the marital assets. And so the limitations are going to depend on whether somebody is married or whether they are single at the time that they are applying for Medicaid. So for income, I should also mention the income of a spouse is thankfully not considered. So it's the income of the individual who is seeking care that is considered determination.
That's very helpful.
And then I had alluded earlier to the snapshot date, and I think it's helpful for folks if we define what that is. That's going to be the first day of the month in which somebody began receiving continuous care in a continuous period of
institutional care.
Institutional care. Exactly.
So like March the 1st for this month, right?
That's right.
Okay.
And that is going to be 30 consecutive days.
Okay.
In a medical facility or a combination of 2 or more medical facilities. Yeah. So that can be a hospital and then into a nursing home. And so that 30-day mark is what would be considered, and then going back to the beginning of that month.
Gotcha.
That is the snapshot date. And so that's the date that the look back period will be based on. And that's the date that they'll be looking at what assets does somebody own, what assets have maybe been transferred in the previous 5 years.
Gotcha.
And I should also mention that these asset limitations we'll talk about, those do remain in place for the individual who is receiving Medicaid and institutional care for the duration that they are receiving Medicaid. Right. So it's not a one and done situation. That varies a little bit for the spouse. The spouse can receive additional assets after that calculation is made. But that means that if somebody's asset picture changes, which is something we'll talk about a little bit later, there may be the need for some help in order to maintain eligibility for Medicaid once somebody's qualified for it.
Right.
So getting right into the assets, this is what somebody can own and become eligible for Medicaid. So we'll start with cash.
Okay.
Stocks, bonds, liquid assets is what we refer to those assets.
It's a good place to start.
$2,000 is the limit.
Did y'all hear that? And that's in the state of North Carolina.
That's in the state of North Carolina.
It's not a lot of money in assets.
$2,000 is what the bank account or all bank accounts for the individual have to hold, not a penny more, in order for Medicaid to begin paying for long-term care. However, there are some larger assets that are not counted towards that $2,000 figure. So that's cash, stocks, things like that. A house is not counted. So somebody can keep their house and receive Medicaid.
Did you hear that? This is why you need an attorney.
Right. As long as the equity of the house does not exceed $688,000, which that would catch, in this area a lot of folks that have homes that do not exceed that equity level. So that's the good news. Somebody can keep their home and receive Medicaid.
And may I interject a minute? And I think some of the folks who view this, Lucas, will be I want you all to absorb that, because so many people come to me wringing their hands. What am I going to do? I can't take care of my wife or husband anymore, and we own this house, and there's hope. I want them to hear that there's hope. So
certainly,
thank you.
Yeah, and I also want to highlight that what we're talking about right now is becoming eligible for Medicaid.
Right.
Folks are also worried about what happens to their house after they've passed away because of something called Medicaid estate recovery. But we do have some tools that can help with that issue that we'll cover.
I love it.
Later on.
I love it.
Somebody can also have a car of any value. It doesn't matter how expensive the car is. That is not counted towards somebody's assets to receive Medicaid. Somebody can have up to a $10,000 cash value of whole life insurance. So life insurance policy. Some folks might own a portion of real property and not the entire piece. So if somebody is a 1/3 owner, let's say, in some farmland, that they own as this is a legal term, but tenants in common
Yes.
with two other owners, meaning they each have they have their fractional shares. That ownership is not considered towards Medicaid.
Cool.
So that's because DSS doesn't want people to force sale of other people's property in order to become eligible for Medicaid. A prepaid burial contract is something that is not counted against somebody. So that's a helpful asset. Sometimes we'll talk about a spend down plan, which isn't necessarily about spending money, but just converting the nature of assets. So instead of having a $20,000 bank account, somebody can have a $20,000 burial contract.
There you go. And it's done.
A way to transform the nature of the asset.
Mm-hmm.
And then any personal items. So generally, the value of personal items, clothing, jewelry, etc., is not taken into consideration in qualifying for Medicaid. So some of those important heirlooms that folks may hold, they don't have to worry about selling those at auction or otherwise in order to qualify for Medicare. And so that, what we just discussed, that list of assets, that's for a single individual seeking care. There's also, if somebody is married, there are some additional assets that can remain within the family unit. So if somebody is married and seeking Medicaid to pay for long-term care, then all of those same assets we just discussed still apply. However, in a marital situation, the entire marital estate would be considered. Okay. So all assets owned by the person seeking care and the spouse. So both. But
all the liquid assets owned by both. Or
so it would be all of the assets.
Gotcha. All of them
generally would be considered. But because they're looking at both, they also allow the spouse to keep some assets, more assets than what we had just considered. So,
got it. Because the spouse needs to live too.
That's right.
Gotcha.
And the community spouse is what the spouse is generally called in this scenario because they are living in the community. The spouse who is seeking care, is the technical term is institutionalized spouse. I prefer the term person seeking care or person receiving care. So that's how I refer to that individual. But so in addition to the list we discussed, the spouse is allowed to keep 50% of the total countable assets. So those are things that we didn't just talk about. We talked about non-countable assets. Mm-hmm. But for anything else, business interests, large stock portfolios, things of that nature, the community spouse is allowed to keep 50% of those. Mm-hmm. That's known as the community spouse resource limit. And it's at a minimum of $32,532. So if half of all the accountable assets, or if all of the countable assets are below that $32,532 figure, then the community spouse can keep everything. There's no need to spend any of that down. But the maximum for that 50% ownership allowance begins to phase out as at $162,920. So that's when we would have to look at some other options to convert the nature of assets. We had talked earlier about the look back period, and that's where some folks might get caught or might have an application denied. And some of the issue with that is just self-help, where folks have heard from a neighbor or a friend that, well, if they just give everything to their kids or sell things at a marked discount, then in that situation they can get all of the assets, or at least all the countable assets, out of their name and have no problems when it comes to eligibility. But as we said earlier, it's 5 years prior to that eligibility determination that is what DSS is looking at.
Mm-hmm.
And that's where the financial audit is going to be. It's impossible to really hide anything in that process. But giving or selling any property during that 5-year time frame for less than fair market value is presumed to be for the purpose of qualifying for Medicaid, unless the applicant can prove it was done for another reason. And so it can be hard to prove that if you're giving away a piece of property or selling a piece of property for pennies on the dollar, that was for any sort of gratuitous purpose. It's presumed that that's for somebody's self-interest. And so that can be an issue. And where the rubber meets the road as far as the effects of giving away assets or selling for less than fair market value is in a sanction based on the transfer. And that's essentially a penalty that Medicaid or that DSS will put in place before Medicaid can start being paid. And so this gets into a little bit of math, hopefully not too complicated, but the state of North Carolina has what's known as a Medicaid divisor, which is essentially an average cost of long-term care.
Oh, okay.
That in 2026 is $11,904 per month.
Okay.
And so, just for example, if somebody gave away $100,000 in assets in the last 5 years and now they're applying for Medicaid, and assuming they don't have any ability to prove that it was for any other reason that DSS accepts, that equals approximately 8.4 months where that individual is going to have to pay privately out of pocket for that care before Medicaid will kick in. So essentially they just take the value of the gift that was made, divide it by that divisor.
Gotcha.
And that's how they come up with an amount of time that somebody has to private pay before Medicaid will kick in.
So Lucas, then it would really behoove people to not do that willy-nilly. I'm trying indiscriminately, right? You just don't give away your things indiscriminately. Is that kind of the lesson here?
That's the lesson.
Okay.
And certainly, if something happened outside of that 5-year time frame that I want to highlight, that's not going to be considered.
No.
So if somebody gives away a large amount of their wealth 6 years before they try to qualify for Medicaid,
that doesn't count.
Doesn't count. Not a big deal.
Okay.
But that's a gamble. That's a risk, certainly, that I recommend before doing any gifting, somebody certainly speak with an attorney to make sure that the nature of the gifting is such that it won't cause issues.
Perfect. Thank you. That's helpful.
And there are some transfers that aren't considered, that are allowable all the time. So a transfer to a spouse, a transfer to a blind or disabled child, and some transfers to trust, just depending on the nature of the trust and when that transfer is made. Of course, the transfer to a spouse, that doesn't really help much if Medicaid is looking at the marital estate when it's time for qualification. So those are the general asset and income requirements for Medicaid eligibility.
It's loaded, folks.
There's a lot there, and we're just skimming the surface, really. It's a complicated frame.
And Lucas, you said this is a federally funded program through each state, right?
Right,
so,
administered at the state.
Administered at the state. And so, and in North Carolina at the county level, so with 100 counties, each county is same principles, but we'll have different bandwidth. Right.
Yeah, there is a Medicaid manual that the Social Service Office follows, and that's published by the Department of Health and Human Services. And the provisions in that manual are going to be based on complying with federal law around Medicaid.
And then this is just North Carolina, so each state is different.
Right.
So many of our viewers are from other states. So consult your local Department of Social Services, right?
Or a locally licensed attorney.
Even better. Thank you. So
recommendation.
why might I need to tap into Medicaid? What might happen here?
So if somebody needs long-term care, if somebody needs that kind of care that can be given in a facility that can't be given at home,
Right.
And if somebody doesn't have other options to pay for that care, that's when Medicaid becomes necessary, and it's there for that reason as well. Some of the alternative options to pay for long-term care might be long-term care insurance, which is wonderful to have for folks that have it or are able to receive it. But it's somewhat rare. There's not many folks have that particular option available to them. Only about 15% of folks aged 65 or older on a national basis have long-term care insurance. For that.
Didn't know it was that rare.
And the other option, of course, would be private pay. So for somebody who does have significant assets that they aren't going to necessarily outlive, and if they want to be very specific about the environment in which they live, the community in which they reside, private pay is often the best option for that. So some of the continuing care retirement communities that we have locally are only going to accept private pay and not Medicaid. So that's one reason that folks might not use Medicaid. But those who do need Medicaid should not feel shy about making themselves available to that program, which is there for the reason of paying for long-term care. And in fact, I saw a statistic that about 67% of seniors rely on Medicaid for long-term care expense.
That's a lot.
The main reason is that long-term care is expensive. And folks, could easily outlive their own assets, but for this.
I guess if we could make an application right now for some of our viewers, particularly adult children of aging parents and grandparents, is make plans for yourselves now, right? Just start making plans for yourselves now.
Yeah.
That's what gets into the world of estate planning and care management. Just start making your plans.
Right, exactly. And, I think the timing of when somebody needs Medicaid, that's going to be something that is more helpful to talk through with a care manager, Four Seasons or a similar organization, as opposed to speaking with an attorney about that piece in particular, because that's going to be based on how safely somebody's living at home, whether they have any specific conditions that need care in a facility as opposed to some kind of home health option being available. So it's really important to use a care manager to actually determine when it's time to move into a different style of community. And then at that time involve an attorney to help with the nuts and bolts of qualifying for Medicaid if that's going to be necessary for that living situation. More specifically, for somebody who has Medicare and then needs to go into a long-term care situation, it's important to know that Medicare stops paying for long-term care after it's paid for 100 days during a benefit period, which a benefit period ends when somebody has been out of a hospital or out of a nursing home for at least 60 days. And so it's feasible that somebody could get more than one benefit period, but that would require 2 months of living somewhat more independently, which can be difficult depending on the situation. But that's broken down a little bit more. So Medicare will cover 100% of that cost of long-term care for the first 20 days. Days 21 through 100 do require a daily copay of, I think it's $209, $210 per day. Right. And then after 100 days, as we noticed, there's no
Done.
coverage at all. So that's a technical time that Medicaid might be necessary. If somebody is living in a facility, Medicare has been paying for it, and Medicaid sends a letter saying, they've reached this limit, that's a time that Medicaid might be necessary.
That's another one of those situations where it's good to have a care manager to help navigate you through that, because that's challenging after hospitalization. So, yeah. Here's your team.
Finding the right place and the right person.
So much. Well, then why would I need an elder law attorney or support in this? Tell us about how elder law and Medicaid navigate together.
So I've alluded to this sort of question throughout our conversation so far, but I think if we want to delineate sort of chronological times that a Medicaid eligibility-oriented attorney or elder law attorney might be helpful, we start with just future Medicaid planning. So this is where somebody is living at home independently, very much lucid, has the mental capacity to execute any legal documents that might be necessary, and might not be needing any sort of long-term care for at least the next 5 years, hopefully longer than that, in case any transfers are going to be helpful. During that time frame, there are transfers to sort of types of trusts that attorneys can draw up that will help protect assets in the long term and still allow somebody to qualify for Medicaid. If that's a lot easier if it's outside of that 5-year time frame. Probably more common, though, is the crisis planning environment. And so this is where somebody has either tried to qualify for Medicaid by filing an application alone, and that might have been denied, often because of transfers that took place within the last 5 years prior to that application. An attorney can give certain ideas that might help an individual cure some of those transfers. So, for instance, if a parent who needs Medicaid gifted their child significant assets or real property, and DSS catches that, one thing that can be done is the child can gift that back to the parent. And then that asset can be transformed in some other way that makes it a non-countable resource, so that Medicaid becomes eligible or becomes possible, and the transfer that caused the issue has gone away. That's been fixed or reversed at that point.
Very creative.
That's one thing an attorney can help with. And then just generally in helping create a spend down plan for folks who might already be in a facility. Medicare might be paying for that. There are certain creative spend down options that are available based on what assets are not counted towards Medicaid eligibility. Something like purchasing a new car, for instance, that the community spouse could continue to use to go shopping, have a social life, etc. Purchase of clothing, personal items, the repair of a house, that's a big one. So somebody can take their large fortune that they've amassed in their bank account and make long-term repairs to their house, which they are allowed to keep their house and receive Medicaid. So that's a good place to put some of those funds. And then sometimes it's a situation where somebody is going into a nursing home, but they have been helped or cared for at home, often by a child, for a long period of time. A caregiving contract can be a way for funds to go to the child without it being construed as a gift. If that child has been caring for the parent, doesn't have to be a child, but often is, and a doctor signs off to the effect that that care allowed the parent to avoid nursing home, then a caregiving contract paying the child for caregiving services is a totally reasonable situation that allows what might otherwise look like a transfer or a gift to be a legal situation.
That's very creative.
and then the purchase of a burial contract or life insurance within the limits that we talked about earlier.
Wow.
Those are other spend down options, but of course these options will be dependent on somebody's specific asset situation and their specific needs.
I can speak to our audience. This is something that some of you have asked over the years, and this is why the services of an attorney are essential to protect those assets. So I'm hoping you all are gleaning some pearls from this right now.
And so moving forward, I guess in the chronology, the other time that somebody might really need help might not be in a crisis situation of needing to qualify for Medicaid, but somebody might already be receiving Medicaid and might have been receiving Medicaid for a long time. And then something unexpected happens, which is for most folks would be good news to add to their asset level, but for folks who are receiving Medicaid, it can cause some complication. Something like receiving an inheritance, even if it's an unanticipated inheritance, that can cause issues to Medicaid eligibility on an ongoing basis.
Yes.
Or perhaps somebody gets divorced and then they're already in the long-term care facility environment, divorce settlement. So the marital house then gets sold. That's an issue because the house, which was not counted, is now cash, which is counted.
Yes.
And so there are certain options available to folks who find themselves in those unique situations. Certain types of accounts and trusts that can be set up, which will allow Medicaid to continue paying for care, and the funds would be held in a trust for the person's benefit.
Perfect.
With the catch that the state of North Carolina is the final beneficiary of that trust after the person passes. So that's the trade-off.
Wow.
And another situation in which an attorney can be helpful is in preserving, especially land, houses from Medicaid estate recovery. So that's forwarding to the next point on the timeline. Somebody's been receiving Medicaid and then they pass away. So the rule about somebody getting to keep their house and receive Medicaid, that applies while somebody is alive.
Okay.
Once somebody has passed away, Medicaid can file a claim against that person's estate. And as part of the law surrounding claims of creditors, that can require the sale of real property. If there's not other money around, which there likely wouldn't be in that situation, to pay a large Medicaid claim, which the claim is going to be the amount that Medicaid has paid for that person's care
during that time.
So it can be a substantial amount after somebody passes. One way in which that sort of fear of Medicaid being able to come and take the family property or take the house after somebody's passed away, and it wouldn't be Medicaid doing that, I should clarify. It's the Department of Health and Human Services down in Raleigh would submit a claim against the estate, which then the executor of the estate has to deal with. One way to get around that is by preparing certain types of deeds during lifetime that might involve having a joint owner on the title with rights of survivorship.
Got it.
And so the joint owner can own a small percentage of the property, with the majority still being owned by the person who is receiving Medicaid.
Gotcha.
And then at the person's death, who is receiving Medicaid, their large percentage automatically passes to the other owner, so they don't own a house at the time.
Perfect.
That's one technique that can help protect property from this Medicaid estate recovery, at least under current law. And I'd say those are the big times that an estate attorney who has some Medicaid specialization or knowledge would be helpful. And then there are certain estate planning tools that should not be overlooked in things. And so something like the community spouse, the estate plan of the community spouse, making sure that the person who's receiving Medicaid is not the sole beneficiary in case the community spouse passes away first. Doing some work, and that might be a simple update on the will or the trust of the community spouse is a really important part of making the whole picture fit together. Otherwise, that unexpected inheritance could be from a community spouse that could impact Medicaid eligibility for the person who is receiving Medicaid. And I would say in that instance, it's perhaps unexpected, but not unavoidable to make sure that instance doesn't take place. And that's through just doing a simple estate planning for the spouse who's in the community. Those are, I think, the highlights of what an attorney might be.
So, this is so thorough. So, Lucas, really, if you anticipate needing Medicaid for a loved one, you need contact an attorney. I think is a good idea, an experienced Medicaid attorney. But I'm really intrigued here. If you have a loved one who is receiving Medicaid to pay for where that person lives, and there's that community spouse, it really sounds like there should be an attorney helping to protect against some other interesting unforeseeable circumstances. I hadn't really thought about that before.
I think it's helpful for both of the individuals who are married to each other to be, to the extent possible, involved in the planning process, because then some unintended consequences could be avoided.
It's a lot. It's a lot. And here's why our audience, wherever you live, if this is your path or the path of your loved one, please seek the advice of an expert elder law or elder estate planning attorney to protect you and your assets or your loved one's assets. It's just the right thing to do. I'm a big believer.
Well, and I'm a big believer in it. It really takes a team to help somebody with their care. And so an elder law attorney, even if there's no legal work that needs to be done, will often have a fairly substantial Rolodex of others involved in the care network. And we'll be able to get people pointed in the right direction.
I love that.
Which can be easier than just searching things on Google.
So much easier. Go with the trusted people you know. What final words do you want to share? Do you have a parting shot, or was that just a good parting shot right there? Trust the Rolodex.
I think trust the Rolodex, and I appreciate working in this field, and I appreciate others that are working in this field as well. And I think it really does take a village to make sure that folks are properly cared for in our culture, in our environment. So,
thank you.
Happy to be part of that.
I'm so glad. He's a wonderful community collaborator with us here at Four Seasons, and that Van Winkle law firm is. So thank you so much. This was a lot. I'm going to have to listen to this again. All the fabulous details. So again, if you want to know more information about Van Winkle Law, go to www.vwlawfirm.com, because this is really, our topic today really might have some of you thinking, I do need to talk to an attorney about my mom, dad, grandma, grandpa, whomever. This is the time to start having those conversations. And for any more information about Four Seasons, give us a call, 866-466-9734, or our website, which is fourseasonscare.org. And thank you, Lucas. I'm so grateful. I'm so grateful. Absolutely. And join me next week, Monday, March the 23rd, and I'm going to have another special guest, who serves in the role as a fiduciary, who sometimes interfaces with estate planning and elder law attorneys kind of roles. So there's wonderful communities out there, y'all. There's lots of resources, especially here in Western North Carolina, to help you live well and age well. And it's a privilege for all of us to be of service to you. So I hope you have a wonderful Monday. Thank you. Bye now.